Hi, it's Guy DiMartino. I'm a Northwest Indiana estate planning and probate lawyer. Talk to you about a conversation that I had with a distraught widow in the last few weeks. And this is what happened. She wanted to know, because of her husband died without a will, what she would be entitled to, whether she would be entitled to all the property or whether she would have to share the property with other folks. So here is my response, and here are the legal issues. I asked, were you married to him? Yes. Do you have any children? Yes. How many children? 2. So there's a word that we use in the law, and that's called intestacy. And an intestate estate is an estate in which there was no written will. So because her husband died without a will, it's an intestate estate. And so what that means is that the distribution of property will go under the state law. And the state law has a set defined way that property is distributed based on familial lineage, based on how close of a relationship there is. So in this fact pattern, we have a surviving spouse who had children with the person who passed away, and we have 2 children. So under Indiana law, the probate estate, the stuff that needs to be probated, will be split 50% between the surviving spouse and 50% between the children. This does not usually include life insurance proceeds, because if there was a beneficiary designation on the life insurance, like if the wife, surviving spouse, was designated as the beneficiary on the life insurance, that goes to the spouse. Same thing with any retirement funds, any IRAs, any type of bank accounts that the husband might have had in his own name. Those usually will go by beneficiary designation. If there was no beneficiary designation on these accounts, then they would come into the estate and they would have to be split up 50% to the surviving spouse and 50% to the kids. Now, the marital home, if it was a home that they got together when they were married, that is the spouse's home, because the deed is most likely by tenants, and the entirety means that married folks have purchased this property. On the other hand, if this wife married her husband and the husband had the home before they got married and they never changed the deed, and the deed was only in the husband's name, that would be something that would have to be probated and go through the probate statute, and then they would be split up 50% for the surviving spouse and 50% for the kids. So that's the analysis, and that's how this sort of works, and how a lawyer would look at it, and how it plays in with the law. And so we take this fact pattern and we say, how can we avoid it? Very simple. With some estate planning documents. If this guy only had a will, and typically when there's a spouse and kids, in the typical will, usually the spouse leaves everything to their spouse. And then if when both spouses pass away, things go to the kids. And that's typically the way wills are written, but you can always change the distribution, but at least that's something that would have been contemplated before death. So to resolve this whole issue and require to follow the state law regarding distribution of assets, all this guy would have had to done was sit down, eat with a lawyer or with a proper legal form, and prepare a will saying where he wanted his stuff to go. If you have any questions about an Indiana estate matter, you can always give me a call. If you believe that this information has been beneficial to you, or you know somebody who would like this information, please share this episode. Until the next time, have a great day.